I welcome you all again to Janjatiya Gaurav Varsh celebration. Our first panel for today's program is Tribal Health and Public Policy. Our dais is already full with exceptional speakers in front of us. So just to give you a brief snippet of the whole plenary, the Constitution of India, we all know, recognizes special status for tribal communities and also provides special provisions to safeguard their rights and culture. However, despite their large number, despite these provisions, tribals have often remained marginal, especially in geographical, political, and economic sense. And because of this marginality, they've also remained marginal in the national psyche. I hope by having this discussions of the sort and also programs further in the year, which will enjoy and celebrate and also make efforts to keep the tribal culture, tribal language, and other things which will help us to bridge that marginality. So the plenary today is on tribal health and public policy. We all know that tribal people have poor health status and various unmet needs, and healthcare system have been there, but largely still, till today, the healthcare system among the tribals have remained presumed within the rural healthcare system, but we know that tribals have their own specific needs. They have their own culture, their own traditional knowledge system that need to be incorporated when a healthcare system need to be devised for them. And in that scenario, public policy emerges as a very important element. So our first speaker for today is Professor Ratnabali, an accomplished academician and an administrator. She teaches at the Faculty of Law and currently the Dean Academic Affairs. Her impressive educational background includes PhD in law and LLM from also law from the University of Delhi, along with a postgraduate diploma in human rights, humanitarian law and refugee law. With a strong academic foundation, Professor Ratnabali's expertise lies primarily in human rights, focusing particularly on issues and rights of marginalized section of society, with special emphasis on tribal indigenous people. Her work looks at the human rights issue with a holistic approach involving interdisciplinary, such as social and cultural anthropology and sociology. So we'll start with our session right ahead, and I invite ma'am to deliver her talk.
Namaskar and very good afternoon. Respected Professor Gautam Kshatriya, former Professor, Department of Anthropology, Professor Anil Kumar, CEO, University of Delhi Foundation, Dr. Nidhi Balyan, who is moderating today's session, Professor Mitra, other faculty members from University of Delhi Department and colleges, as well as JNU, I can see Madam there. Other distinguished invitees, resource persons, and my dear students and participants. It's indeed an honor to be here on the Janjatiya Gaurav Varsh Day, when we are remembering the ideals for which Bhagwan Birsa Munda ji had given up his life. And we are here to look at certain issues which still lingers in the, I would say, not just in reality, in the field, but also where we need to change our own perspective about tribals. Because as our keynote speaker in the inaugural session, Srimati Damayanti, had mentioned that if we want to see Viksit Bharat by 2047, it is not possible without talking about developing the tribals. So in that context, I would like to give my presentation on Indian Constitution and the tribes. Now, if you look at, first of all, who is a tribal? Many a times when we say tribal, we feel that tribal is a homogeneous community. No, it is not. So, if you look at the history or evolution of this particular term, tribe, it means a particular type of society different from the rest. And in addition, if you come to the 19th century definition of tribal, it meant a particular stage of evolution. That means those who are considered as tribal are primitive, are considered to be primitive. Or in terms of if you look at the definition of indigenous, people given by United Nations, the understanding is that these are people with priority of settlement. But that definition is contextualized in the understanding of colonization. Where there is no colonization, then it becomes difficult to fit into that definition. So in India, when we say tribes, they are also understood by different terms. What are those terms? Adivasi, Adimjati, which means original inhabitant, or Vanvasi, or forest, which means forest dwellers. So the tribes are, as I had said, they are not, homogeneous. It's a heterogeneous tribe. Now, what are the common characteristics of a tribe? If you look at the characteristics, you'll find that when we say a particular group of people is a tribe, you will have some sense, some sort of geographical isolation or semi-isolation. Second, they may be unacculturated or partially acculturated into national society. Largely or entirely, you will see that they are independent of the national economic system. They have ethnic distinctiveness from the national society. Then economic base is tightly dependent upon the environment, and they possessing leadership, but no or less national representation, and few, if any, political rights. And these are the characteristics as determined by Robert Gutland. This is not my creation. Next slide, please. So if you look at the Indian context, when we say scheduled tribes, which are in other words Anusuchit Janjati, they are defined to be tribes which are identified by President's order under Article 342 as scheduled tribes. So in other words, when we say scheduled tribe, it is an administrative term that is used for the purposes of administering certain specific constitutional privileges, or it can be in terms of protection and benefits for specific sections of people considered as historically disadvantaged. And the United Nations and multilateral agencies of UN generally consider the scheduled tribe as indigenous peoples. And the scheduled areas are areas which are, declared by President's order as scheduled areas as per paragraph 6(1) of the 5th schedule of the Constitution of India. Now, if you look at the distribution of scheduled tribes, you will see that there are about, as per the official document, there are 635 tribes, which constitute about 8.6% of the total population of India, and they live in 15%, territorial area of India. But you will see that since most of these tribals are residing in those places where development activities are being taken, 1/3 of the population displaced by development projects, they are mainly tribals. Next. So if you look at the tribal land relationship, because we need to understand why land is very important for tribal and what kind of connection or relation that they have with the land. So the tribals in general, you will find a common thread amongst them, that is that they have a unique relationship with their land. So the land where they're residing are mainly the land where for hundreds of years, generation after generation, they have been residing. So they belong to their territories, and which are the essence of their existence. Many a times you will find that the territory itself is the identity of the tribals. So in many of the Northeast, you will find the places are in the names of the tribals. So you have Garo tribe, then you have Garo Hills, isn't it? You have Khasi tribe and Khasi Hills, Janjatiya tribe and then Janjatiya Hills, and so on. So therefore, there is a close connect of tribals with their land. And if you look at tribal religion and belief and faith system, you'll find that these lands are the abode of their spirits and the dead. It is a source of their science, technology, the way of life, their culture and religion. So therefore, land has to be understood in a holistic sense in the context of the tribal. It cannot be understood as a socio-economic, piece. Because if you look at Haryana or, where in the neighboring NCR region, you know that many of these land were acquisitioned by the government for development purpose, whether it's for building highways or high-rise buildings. So there is no such qualms about acquiring them because they don't have so much of connect with their land in the sense that we see in the case of tribals. So it is easy to compensate when we talk about acquisition of land. In other contexts, you can give monetary compensation and that kind of satisfies. But when we are displacing a tribe from their, traditional land, it's not that money can, compensate what they are losing. Next slide, please. So if you look at the Constitution of India, the constitutional provisions that kind of tries to protect or give benefits and privileges to the tribals, one can talk about the preamble of the Constitution, the fundamental rights, the directive principles of state policy, which is part 4 of the Constitution, and then Schedule 5 and 6. There are other statutory, legislations or provisions which are there in PESA 19, Panchayat extension of in the scheduled areas, then Forest Rights Act, then you have the New Land Acquisition Act of 2013, which are very important in the context of, protecting the rights of the tribals vis-a-vis their land. But since I have been given the topic of talking about constitution in the tribe, I'll be focusing on the first 4 only. Next slide, please. So if you look at the preamble of the Constitution, we all know that preamble talks about, securing socio, economic and political justice, equality of status and opportunities, liberty of thought, expression, belief, faith and worship, promote fraternity amongst all, assuring the dignity of individuals, unity and integrity of India. So since tribals are also the citizens of India, all the, ideals and aims that are envisaged in the preamble are also important in the context of tribals, and particularly when we are talking about equality, when we are talking about socio-economic justice, when we are talking about having the liberty of their belief and faith system. So if you look at the judgment given by the Supreme Court in S.R. Bomai versus Union of India, it was said that preamble is part of the basic structure of the Constitution. Prior to that, there were differing opinions of the judiciary as to whether it is a part of the basic structure or not, whether the preamble can be amended or not. So it was in this particular judgment that it was decided that the preamble is an integral part and it is part of the basic structure of the Constitution, so we cannot modify that. Now coming to the fundamental right, next slide please. So tribals being citizens, they all enjoy the fundamental rights which are given in part 3. But I would like to specifically focus on the specific rights given to tribals, and those, obviously, they are the ones who are living in the scheduled areas. So if you look at Article 19(1)(d), 19 is all about freedom. So 19(1)(d) specifically talks about right to move freely throughout the territory of India. Then 19(1)(e) talks about right to reside and settle in any part of the territory of India. So if you look at these two rights, you will find that this freedom is given to all citizens, but then there are restrictions which can be imposed with respect to these two clauses. So it says that you can restrict those freedom in the context of the scheduled areas, movement and residing in those scheduled areas, and that's how we have norms or rules where the government issues inner line permit or protected area permit. Without these permit, you cannot enter into those areas. So these provisions are being made or enshrined in the Constitution to ensure that the tribes, their land as well as their culture are mainly remaining intact. They are not, influenced by outsiders settling in their area. Next slide, please. Now, if you look at the directive principles of state policy, which is particularly focusing on what the, government should take care of while formulating policies, it says that, fundamental rights and directive principles they supplement each other. Because as a right you can enforce, you can go to a court of law to forest enforcement, but you cannot enforce directive principle because it is a policy which the government has to take into account. So therefore there is a close interrelation between the fundamental rights and directive principles, because it is through the state enforcement action taken under Part 4 of the Constitution, that is the directive principle, that the fundamental rights enjoyment and protection shall be strengthened. So these are not mere declaration, and all the legislative policies, etc., should take into account what is given in the directive principles. Next slide, please. So if you look at directive principles of state policy, Article 39 Clause A talks about obligation to protect livelihood. And when we are talking about livelihood in the context of tribal, I've already mentioned that many of them are dependent upon the forests and natural resources for their livelihood. So therefore we should not take away, for example, if you look at the British era and much later also, the Forest Right Act prevented the tribes from accessing the forest for their daily needs. They could not collect the traditional forest produce for their own livelihood, isn't it? So these were infringing, and therefore, like the Forest Act of 1927, it was later on amended after we got independence. Much has been done, but then there is a lot which needs to be done in this regard. Article 39B particularly talks about obligation upon the state to secure community management of natural resources. We just heard the keynote speaker in the previous session who talked about emphasis on group community rights rather than individual rights. So many of these spaces in tribal inhabited areas are common spaces. They may not be under the land records as an individual property, but most of it is community community resource. So the community as a whole uses it, but there is no individual ownership. So therefore, such kind of spaces need protection. And Article 39C talks about obligation to secure equitable distribution of economy as to prevent concentration of wealth. Article 39C, I feel that it is important, particularly in the context of, development projects that we do. Say, for example, many a times what happens is we may be having a hydroelectric project in a forested area. Obviously, hydroelectric project needs water to be flowing down from a height, and that of course is in those areas where mainly tribals inhabit, because वो hilly region होगा, height से पानी गिरेगा, तभी तो आप hydroelectric project generate करोगे. But many a times when you are trying to build these hydroelectric projects, you have to displace those tribals who are residing there. But the question is, from the power which is generated, how much of it goes to that tribal community? How much of the profit or the earnings, revenue that comes from that particular project is invested in the development of those communities? How much is watering down? Are they only bearing the brunt of displacement? So I think when we talk about development projects in such areas, we also need to see that the benefits of those development also goes to those communities who are sacrificing their land and livelihood and so on, fine, for the purpose of that particular development. If not, when we talk about preventing concentration of wealth, equitable distribution of economy, I think at least for that particular development project, we can include in that particular plan itself that how that particular community will be benefited should be very much part of such project proposals. Next, please. Now, coming to Schedule 5. Schedule 5 and 6 are very important, provisions in the Constitution, particularly in the context of the tribals. Let's see what are they. Now, Schedule 5 Part A says that states having scheduled areas has to be administered as per this schedule. So I've already told you that President can identify that these are scheduled areas. So if a particular state has scheduled areas, then in that case, it has to be governed in line with these schedules. So the governor of the state has to submit a report to apprise the President of India of the administration of these areas. And the executive power of the union, even though there is a state government, but the executive power of the union extends to these areas also. Next slide, please. Now, coming to Schedule 5, Part B. Part B says that there has to be a tribal advisory committee constituted, right? And the maximum number of persons in the tribal advisory committee has to be 20. 3/4 of these members shall be the scheduled tribe representative in the state assembly itself. But many a times the state assembly, the ST representation may be less. It may not be, 20. So in case there are a vacancy, even after taking 3/4 of the ST members from the state legislative assembly, the rest of the vacant position can be filled by other members of the tribe. Now, what is the duty of the Tribal Advisory Committee, or TAC? It is to advise on the welfare and advancement matters of the ST referred to by the governor of that particular state. So governor may make rules that how many members should be there in the TAC, how should be their appointment, and so on, and how to conduct the meetings, and the rules for governing the operation, etc., can be made by the governor. Next slide, please. Now, Part B of the Schedule 5 also talks about the governor has the power to notify, because all the legislations which are made by the parliament may not be applicable or may not be suitable for the tribal areas. So in case of Schedule 5, the governor has the power to notify which act of parliament or state legislature shall or shall not be applicable in scheduled area or part thereof, and subject to what modification. So this ensures that if there is a legislation made by the parliament, but in the context of that particular tribe, it may not be advisable to implement such a law, then as per the, advice can also be taken from the Tribal Advisory Committee and necessary modification can be made. Next slide. Now, Schedule 5 also gives the governor to make regulation for the peace and good government of any scheduled areas in consultation with the Tribal Advisory Committee. And such regulation which the governor makes can prohibit or restrict the transfer of land by or among members of this ST. So many a time what happens is that within a scheduled area, there may be more than one type of tribes, residing there. Then if you allow them to buy land in each other territories, that may kind of, give a point of discontent or friction amongst the tribe. So therefore, governor can also make a regulation that this tribe can buy and transfer their land within this particular territory. The second tribe can be, given the liberty or freedom to buy and transfer land within a particular territory, and this can be done by the governor by making such a regulation in consultation with the Tribal Advisory Committee. So therefore, such kind of regulation can regulate the allotment of land to members of ST. The governor can also regulate money lending business and so on. Next slide, please. So Schedule 5, Part C, I have just talked about A and B. Part C provides the power to the governor to modify the scheduled areas or redefine the scheduled areas. So if the governor thinks that the scheduled areas needs to be expanded, it has to include certain other areas, neighboring areas, it can redefine it. If it thinks that now urbanization has come, there are other population residing, so this needs to be maybe shrunken, then it can, propose it. So therefore, Schedule Part C talks about, redefining the scheduled areas. Part D says that whenever such an amendment is being done, it shall not be considered to be an amendment of the Constitution under Article 368. Because if you want to amend under Article 368, there are certain, requirements which are to be fulfilled. In certain cases, you need 2/3 majority. In certain cases, you need, simple majority. So this kind of amendment is beyond the purview of Article 368. Next slide, please. Now, if you look at Part B, I just want to emphasize upon what are the criteria that can be, used for declaring a particular area as scheduled areas. This is mentioned in Part B of Schedule 5, and it says that there has to be preponderance of tribal population. So you should have majority of the population should be tribals in that particular area, compactness and reasonable size of the area, is second. Third is viable administrative entities such as a district, block or taluk, and economic backwardness of the area as compared to the neighboring areas. So these are the criteria which the governor can take into consideration while declaring, which the president can take into consideration while declaring a particular area as, scheduled areas, and governor can also keep in mind these criteria while proposing for redefining the scheduled areas already determined. Now coming to Schedule 6. Schedule 6 is only applicable to 4 states of the Northeast, and if you look at this Schedule 6 as compared to Schedule 5, more autonomy has been given to the tribals. So there are district and regional council which are envisaged under Schedule 6, and they can make laws for allotment, occupation, use of land other than reserve forests for various purposes. So they have the power to, these district and regional council have the power to make laws. Second is how to manage the non-reserve forest area. For that also they have the power to make laws. Then they can also make laws for the use of canal and water resources for agriculture, regulation of shifting cultivation, establishment of town committees, councils and so on, appointment and succession of the headmen and chiefs. You know that most of the tribals are headed by a chief or a headman, so their succession, appointment, etc. can also be done by these councils, and what kind of social custom they would like to take it forward, because they have the right to conserve their customary laws also. So governor's assent is required to come into effect, but these laws can be proposed by the district and regional council. Next. If you look at the powers of regional and district council, they may constitute a village council also, okay, for the trial of suits and cases, because Schedule 6 areas, they can govern by their customary laws. So therefore, the village council or courts can do the trial of suits and cases between parties, all of whom are scheduled tribes of that area, other than those specified by the governor. So amongst a tribe, whatever disputes are there, they can be settled by these village council or village courts. Then the regional or district council also can appoint members of the village council or presiding officers of the court. They can prescribe and lay down the procedures for trial and enforcement of their decisions. They may also establish and manage primary schools, agriculture, animal husbandry and other community projects. They can have their own district and regional funds and may assess and collect land revenue, impose taxes, grant licenses and leases for minerals also. So if you compare Schedule 5 and 6, lot of autonomy is given to those in the 6th schedule. Next slide, please. So if you look at Schedule 5 and 6, the Supreme Court in Samatha case said that these 2 schedules form an integral scheme of the Constitution with direction, philosophy and anxiety to protect the tribal from exploitation and to preserve vulnerable endowment of their land for their economic democracy with liberty, equality, fraternity and dignity of the person. I would like to request all of you who are sitting here who have not yet read Samatha judgment, kindly read it, because it kind of captures the philosophy behind making such special provisions in the Constitution for the tribals, but still remains, I would say, unimplemented in some of the cases. Next. So, if you look at T.N. Godavarman case or Samatha case, Narmada Bachao Andolan case is more related to displacement, so you can ignore that. But I would also like to ask you to read the judgment of the Orissa Mining Corporation Limited versus Ministry of Environment, Forests and others, which is also called in short as Vedanta case, right? Now, quickly, because I've been asked to wind up very quickly, I will just take you through the important provisions. So Samatha case, as I have said, it's talking about exploitation of minerals, and we know that in Schedule 6, the rights license for, they can give the license and all. But if you talk about other scheduled areas, other areas where the tribal reside, then in that case, it is difficult to give such kind of, protection. So in Samata case, the 73rd Amendment Act 1992, which talks about the applicability of Panchayati Raj, Extension Act to the scheduled areas. There, if you look at clause M, it says it has the power to prevent alienation of land in scheduled areas and minerals to be exploited. Okay, it should be done by the tribals themselves, either individually or through cooperative society, rather than some company coming and doing it on their own, because they would never get the benefit of it. Next. These I will skip. You can read the judgment on your own. Now, in Narmada Bachao Andolan, which is about displacement of people by the hydroelectric project, in this context, I would like to, underscore that one has to look at the rehabilitation sites, whether they are being given more benefit than the place where they were residing, in order to see whether, they can validate the displacement. So, last is the Orissa Mining Company, which I would like to focus. I think this is for the first time that the Supreme Court talked about. Now, why should we talk about judgment? See, after all, when you have a law, its enforcement plays a very important role, and judgment given by the Supreme Court has the force of law, because it has to be implemented by all, right? So if you see the Vedanta case or Orissa Mining Corporation case, it is one case where you will find that the court is talking about the protection of cultural rights of the tribals. And as I had mentioned earlier in the start of this presentation, that culture and religion of the tribes are deeply ingrained with their land. So therefore, when you are trying to displace, see, this case is about the mining company, Vedanta Mining Company, trying to mine bauxite in Orissa in Niamgiri Hill. And Niamgiri Hill was considered to be god by Dongria Kon tribe. Okay, they say that this is Niam Raja, Niam god hai. So they have rituals, they pray to that particular mountain as god, and now the Vedanta company wanted to mine that particular mountain in order to get bauxite. For bauxite mining, they wanted to do it. That means they will destroy that particular area. Okay, so in that case, they had protested against the mining, and this particular case was fought in those lines only, and the judgment given by the court says that the Gram Panchayat should be given the right to decide whether they want the mining company to be allowed to mine in that hill or not. That means you are trying to give some kind of power to give consent, because we have this concept of free prior consent, isn't it? So free prior consent in the context of indigenous people, that some consent should be taken, because after all, they are considered that mountain as a god. So this particular judgment also clearly brings to the fore the importance of such spaces which we may not be able to understand. We may think this is just a mountain, but for them it is culturally and religiously important, and therefore we need to look at our laws and policies, including the development policies, in order to see whether such law and policy are infringing the basic rights of the tribals or not. So with this, I would like to conclude, and I look forward to your questions. Thank you.